Hey, it's Catherine Franke, and as many of you know, today the judge in Vermont, the district court judge in Vermont, released Mohsen Mahdawi, our Columbia student, from immigrant detention. And so this is a very exciting piece of news, and I wanted to break down how that worked and what the difference is between the immigration proceedings and the proceedings in federal court, because it's kind of complicated. So this is the decision from the judge. It's a 29-page decision, well-reasoned, well thought through. The judge in this proceeding is Jeffrey Crawford. He's a former member of the Vermont Supreme Court, who was then nominated to federal court by Barack Obama and was confirmed by the Senate 95-0. He's an older judge at this point on senior status. So that's the judge that has the case in federal court where the constitutional issues, the free speech issues, are being handled by Mohsen's lawyers. So understand that there's two things happening here. There's an immigration court process and then a federal constitutional claim process. He was arrested and put into detention on April 14th when he went in for a citizenship interview, as you know, by the immigration officials. And so that process will proceed on the question of whether Mohsen can be removed or permanently deported from the United States, having had his green card revoked. And the argument that the government is making about why they have the authority, if not the necessity, to permanently deport Mohsen is that his presence and activities in the United States would have serious adverse foreign policy consequences and would compromise compelling U.S. foreign policy interests. And in support of this claim, Secretary of State Marco Rubio has issued his own statement saying that they have evidence that Mohsen had engaged in threatening rhetoric and intimidation towards pro-Israeli counter-protesters at a protest at Columbia last year. Now, as I've noted in earlier videos, and I think is circulated quite readily, that language of threatening rhetoric and intimidation is lifted from the Columbia University website. That's what the students in JVP and SJP were accused of at this protest. And in fact, it was someone else who was an outsider who engaged in threatening rhetoric, intimidation, and it was Mohsen who actually went up to that person and said, please leave. The person was not a Columbia affiliate. So Columbia still has that language on its website, even though the person who said it or used it to mischaracterize the students has since retracted that language. So just a footnote here that Columbia remains implicated in these student deportation cases. So that immigration process will keep going on its own track. But that's not what was at issue today. What was at issue today had to do with his ongoing detention pending the outcome in the federal constitutional lawsuit and the immigration proceeding. So what we learned from this decision today are a lot of details, some of which some of us knew, but not everyone did, which is that when Mohsen went in for his interview on April 14th, his interview for citizenship, which was completed, and at the end of that interview, the officer who was conducting the interview got up and left and said he had to go talk to a supervisor. And while he was gone, the Homeland Security people came in masks and black outfits, and handcuffed him and took him out of the building and took him to a detention facility right nearby for a little bit, and then went to the airport to ship him to Louisiana into the same facility that Mahmoud Khalil and Rumeysa Ataturk are being held, our other students. But when they arrived at the airport, the plane had just left, much to the disappointment of the Homeland Security folks. So they brought him back to a temporary ICE detention facility, then put him into a prison, which ICE is kind of borrowing beds at the state prison in Vermont. So the goal was to ship him down to Louisiana, just like they have with the other students. But both by accident and then by design, that didn't happen. The accident is that they didn't get to the airport on time. The design part is that the lawyers were ready, went to court, and filed this, what's called a habeas petition in federal court, and that's the case that's now, the judge issued a decision today. And what the judge did on April 14th, when he got that petition, is issue a temporary restraining order saying that Mohsen could not be moved from the state of Vermont or from the United States for 90 days, and that's now been expanded. So what he ruled today, he didn't rule on the underlying constitutional questions. He ruled merely on the question of bail or release pending the outcome of this federal lawsuit. So what the judge ruled is that Mohsen's ongoing detention, having never been arrested or charged with a crime, violates his due process rights. That is to say that the government has to have a reason to hold him during this period when the immigration proceeding is going on, and there are only two legitimate justifications for ongoing detention if there is no history of arrest. In cases like this, one is a risk of flight, that if they let him out, he'll leave the country or go somewhere where they can't actually put him through the deportation proceedings and appear before the immigration court. Or secondly, that he poses a risk to the safety of the public. And in both those cases, the court said, there's no showing that he will flee. He's got big ties here in Vermont. He's got friends, he owns property, this is his community. 125 people wrote letters on his behalf. He obviously has a deep connection to the community. And secondly, there's no showing that he poses any risk to the community. Now, the government did come forward with two statements by a gun shop owner, and another person at a museum saying that Mohsen had come in to the gun shop saying he wanted to buy a gun and that he wanted to do was shoot Jews. The court said that's just not credible. That's not true. Mohsen, there's no evidence that he ever said that. So there's no evidence that he poses any kind of risk to the community. So what's interesting is that the court ends with saying detention like this cannot be used as a form of punishment. It can't be used by the state to retaliate or punish somebody for their speech, and that's exactly what it looks like is going on here. And the court then went on to analogize the way the government is behaving in this case to the Red Scare and the Palmer raids of 1919 and 1920, when the government deported hundreds of people who were suspected of having anarchist or communist views, thoughts, or political commitments. He also said this is very similar to the McCarthy period and the kind of purges and persecution by the state, by the government, of people with allegedly communist views or membership during that time. So he very much situated the current moment in that ignoble past and said this has absolutely got to stop, and that's why I'm going to release him. So there were three conditions on which Mohsen was released. He has to continue to reside in Vermont. He's allowed to go to New York for educational purposes, and as we understand it, Columbia is going to allow him to finish his coursework and graduate. We hope that's true. And thirdly, and he can come to New York to meet with his lawyers. And thirdly, he has to attend all court hearings in person, which is great because it's good to have him in the room and have him be part of the process. So what happens next? The immigration proceeding is ongoing, and we don't have dates where there will be actual hearings in those cases like we have for Mahmoud and Rumesa. And then in the federal court, the constitutional case, where the court has not yet ruled on the First Amendment issues. It's just said there's sufficient evidence to find that he's possibly being retaliated against with his detention. But the full question of whether the constitutional free speech claims are ones that can be substantiated will come up in the next month or so. So there's a briefing schedule on the government's motion to dismiss the habeas case, a motion to say there is no constitutional problem here. Mohsen's lawyers have to file their brief on May 7th, and then the government has to respond to that brief on May 14th, and then the judge can rule anytime after that on the First Amendment constitutional questions. But meanwhile, Mohsen is free. And this is something wonderful to celebrate. And, you know, in reading this opinion today, it was refreshing to see law doing what it's supposed to, and to see a judge apply the law in the way it's supposed to be applied and have justice work. So this is much to celebrate today.